log back on, and usually that really takes care of any issues. We are going to be holding questions to the on Fred's presentation, but we hope that we will leave good time for questions. So please chat them in, and we will make sure that your questions get answered. I just want to familiarize yourself with the chat button. It's a box which is on your lower right-hand side of your screen, and you would send it to you could do it to all panelists, all participants, and just chat in your questions. So if you just want to chat into me right now, make sure that you're comfortable using that feature. That would be terrific. You can say hi. I also know that you can hear me okay and the audio is working. Thank you. The other thing is, above the chat box, you'll see a hand that's raised or a check mark. You can all use those if you would like to ask a question. I will be your moderator for the evening, so I'll be making sure that everything's working smoothly, and that if you have any questions, please be able to just chat into me. So again, I'm thrilled that you attended tonight. I'm very excited what's happening with autonomy, supported decision-making, guardianship. There's some very special pilots that are going on out there, and opportunities so that a guardianship for a person with intellectual or developmental disabilities does not have to be the only option in terms of being able to support your loved ones with challenges. So without further ado, good. It looks like a couple people. Anybody else want to chat into me? I think the is working well. So I will say then, take it away, Fred.
Thank you very much, and welcome to everyone who is attending this webinar. Thank you for the ARC of Massachusetts for providing me the opportunity to spend an hour with you to go over some very basic issues regarding autonomy, supported decision-making, and guardianship, as well as perhaps answer some questions as we go through this, and hopefully we'll have time, 10 minutes to the hour, to have 10 minutes or so to go over some questions. The first I would like to say is, why is this really important? Why is guardianship so important? First is to recognize that guardianship does limit autonomy of an individual. That is, a person's ability to make decisions on how to live, who to work with, how to receive supports. So it transfers autonomy to the person or to an entity, a corporate guardian, or to other family members. So it not only limits the autonomy, it transfers the authority to other individuals. And research has shown over time that many people with intellectual disability experience guardianship as a stigmatizing experience. And there's from self-advocates, we hear often that they find that guardianship is inconsistent with their own view of their roles as adults and citizens of society. And so that's why it's important to be thoughtful about this and think through what our options are. And so there are some key considerations that I want to go over with you before we kind of delve into some of the options and some practical issues for you to be aware of. First is the issue of legal emancipation. I'm having a little trouble moving the, okay. So that's, okay, so I have to click that up there to move that along. So legal emancipation. When someone is under a minority, so until you reach the age of 18 years old, you're considered to be under a legal disability, and that disability is minority. You're presumed to not be able to weigh information, make decisions about advantages and disadvantages of particular choices, able to, sort of see the probable consequences of your choices. And but magically, at age 18, you are legally emancipated. You now are endowed with full autonomy, full authority to make the decisions. And there is a presumption of competence that and I can tell you that I, at age 18, was probably a role model or a poster child for a gap year or two before I went to college. But, I wasn't the most mature person at age 18. And I think that goes for many, many people. But 18 is the age of coming of age, and you are presumed competent. That means that parents and others do not have the right to get access to information, attend meetings. Their rights of privacy are endowed to someone who's 18. So that's an important consideration when we're facing this. The other is, in the case law, a guardianship law, there is a strong preference for any type of restrictions on an individual's decision-making being the least restrictive alternative. So you only want to be granted or exercise that degree of authority over an individual's rights of self-determination and choice to the extent deemed necessary in order to further that individual's expressed preference and perhaps safeguard their health and safety in a variety of circumstances. The key consideration that underscores this entire area is the right of self-determination. The UN Declaration of Rights of Persons with Disabilities that was created in 2006 speaks that every individual, persons with disabilities, persons without disabilities, have an inalienable right to self-determine. I think the best way to describe that was when I hear self-advocates talk about nothing about me without me, implying that we need to be making decisions that respect an individual's right of self-determination. Sometimes those rights and so those decisions may seem risky, may seem not consistent with what I might consider to be appropriate decisions, but again, when the balance, all individuals have a right of self-determination. In those individuals under guardianship, the case law is very clear that guardians or anyone acting a supportive role must respect the expressed preference and the subjective view and the subjective values of the individual they're supporting. The next consideration, and I refer to it as I self-identified, at age 18 I wasn't very mature, yet I found myself as a freshman in college. And so perhaps I could have benefited at that time from some degree of support and guidance. And so everyone is different. And so in looking at this, there's no cookie-cutter approach, and I really want to focus that, underscore that. There is no cookie-cutter approach. We are individuals, we are unique, and each one of us has varying levels of capacity and maturity at any given point of time in our lives. And so this is a very malleable and flexible concept. So what might be appropriate for someone at age 18 or 19 may be wholly inappropriate at age 30 or 35 as maturity and experiences kick in. That's another important consideration. So think about all of this. What does this all mean? Well, that an individual turning 18 should essentially exclusively self-direct. That is, they don't need any support whatsoever, and go forward with that. For many individuals, this may not be the best option. This may be one option that would cause some degree of risk, maybe not tolerable for families person, for parents, and for the individual. So the other decision making is collaborative, supported decision making, and I would say that's probably really not limited to parents, but in our context tonight, let's just focus on collaborative with parents. So there's a mutuality of decision making that's going on. There's no one has a veto power except the individual whose the decisions rest, but it's collaborative. And then finally, exclusive with parent, and that's for individuals who may not be able to, for one reason or another, be able to make decisions on their own, and that would be a full and complete guardianship in that instance. So those are the key considerations as you approach this area and say, okay, I get the fact that at age 18, a person's fully emancipated and presumed competent. I get the fact that we only want to go and exercise that degree of I'm going to move back just a second. That degree of authority that's necessary on using the least restrictive alternative principle. The fact that individuals should be given the right to self-determine, alienable right that's granted, and we respect the subjective preferences. You understand that this is a highly individualized analysis based on where the person is in their life and what they're going through at that point in time. And very globally thinking that, okay, we have the ability to just let someone make their own decisions, totally self-directed, or a collaborative process with others, and exclusively by the parent, where that person has no authority whatsoever, and that would be a full and complete guardianship. So let's move and look at what are the range of options that are around. And for purpose of tonight, I'm going to go through the most restrictive to the least restrictive alternative. And when you think about range of options and conceptualize this, I want you to think about what are the interests that we're seeking to protect. What are the things that we're worried about? What are the things that we want to support? What are the things that we're interested in protecting? Guardianship is really a transfer of decision-making authority from the individual who's granted by sort of inalienable right all of this decision-making authority, and it's a transfer of the authority to another person. It can be a full and complete guardianship, and that's guardianship of the person. So all healthcare decisions, residential decisions, educational decisions, decisions about activities of daily living, medication decisions, housing decisions, etc., would be handled by the guardian with full and complete discretion. There are also guardianships that can be limited. Often you will find guardianships may be limited for health reasons or medical reasons in order to protect the health and safety. There might be an active medical condition or medications that need to be administered and put in force. There might be concern about residential options, so you can expand it a little bit. But other decisions such as who to associate with, where to work, being able to use the bus, being able to use the internet, being able to make decisions about, activities of daily living, the rhythms, routines of the day or the week, would be reserved to the individual who is otherwise subjected to the guardianship. And that can be very expansive. When we, in my law firm, in my practice, when I meet with family members who are interested in guardianship, we go through a list of very specific activities that we would want to ensure that, do you want authority over the person's life in these areas, or would you want those areas reserved to the individual? In Massachusetts, we have something called conservatorship. And conservatorship is nothing more, nothing less than a guardianship of the estate. Because guardianship of the person is health care, housing, personal care and custody type arrangements. Conservatorship is guardianship of the estate. And for reasons that I'll get into in a few minutes, we rarely see conservatorship in a special needs practice where supporting family members with intellectual disabilities. That's because we have other lesser restrictive alternatives to conservatorship. This is only when assets are in the individual's name, in their own name, and often will need to go into court to be appointed a conservator in order to preserve assets of the estate. Recently, I was appointed a conservator of a young man whose mother left him and his brother the house. She didn't have a will. She passed away. Brother and he were living in the house. Situations developed where both wanted to move and needed to move out of the home. And so the house needed to be sold. This individual has been under a guardianship for years, and this was the only asset that he has in his name. So I was appointed his conservator in order to assign a listing with a local real estate broker to agree on an appropriate sale price for the home, negotiate the offer to purchase, to negotiate the purchase and sale agreement, and to handle the real estate transfer on his behalf, and then subsequently to transfer the net sale proceeds into a special needs trust. That only occurred because it involved going to court and getting a conservatorship appointed because his mother and father did not execute a will and a special needs trust for him. Basically didn't do any estate planning, and the house went into, by intestacy, into the name of the brother and him as tenants in common. So that's an example of conservatorship. Often in a special needs practice, that occurs only as a result of an oops, a mistake, or a failure to plan. Advancing. Okay, so the next couple, Roger Guardian, is a form of guardian, and some of the folks on the line may be aware of this. Guardians in Massachusetts are limited in their authority in some important ways. A guardian cannot consent to extraordinary medical decisions, such as transplants of organs and major medical situations, major medical surgeries, operations, that kind of thing, without going to court and get specific authority for those. Likewise, a guardian cannot consent to the administration of psychotropic medication. And so if a person under guardianship or subject to guardianship needs a psychotropic medication, that person is appointed an attorney, and the guardian needs to petition the court for specific authority by issuing presenting a treatment plan and analysis using a substituted judgment analysis that the individual, if they were competent, and a substituted judgment would consent to the administration of psychotropic medication. So that's called a Rogers guardian, Rogers monitor. And in Massachusetts, it's unique in this. Other states do not have this particular procedure, but Massachusetts does, and it comes out of a case involving an individual who was at Boston State Hospital and being administered Thorazine against her will, and she wanted to leave, and the superintendent and the guardian wouldn't let her. And so legal advocates took her case and brought it away to the Massachusetts Supreme Court. She won, and then that case was codified or rolled into a statute, and that's the law in the Commonwealth of Massachusetts. The important piece here is that a Rogers guardian can only stand no longer than 1 year. So a guardian must go back to court every year to seek to extend the authority or to get extended for another year. Again, we're moving from most restrictive to least restrictive, and now moving to the area of a trustee. And I mentioned the fact that a special needs trust is a device that is used by many individuals. I think it's an incredibly vital, fundamental piece of planning for an individual with a disability who needs to safeguard assets from being exploited, from being misused and misspent, and also to assure eligibility for important means-tested, income-sensitive or asset-sensitive government benefits. And the person who operates one of these trusts is called a trustee. And that is a range of options that provides some legal safeguards and legal protection for the preservation of assets. And so as an alternative to conservatorship, we have trustees who can manage a special needs trusts. So I'm going to click down and talk about three other documents. We'll get into this a little bit more specific later on in the presentation. But a durable power of attorney, healthcare proxy, and appointment of advocate are what I call generally supported decision-making alternatives to guardianship. These are documents where an individual will designate a person to help make decisions for them in a variety of areas. Durable power of attorney would be a form of an alternative to guardianship. So it would say, I, Fred Misilo, of where I live, I hereby appoint Joan Smith to be my attorney in fact under this durable power of attorney. On to say, I authorize her to help me with money, to access my bank account, help me write checks, get my mail, deal with the Internal Revenue Service, deal with banks, talk to my doctor. And we have HIPAA, Health Insurance Portability Act appointments as well. But these are really substitutes for a guardianship. And I can also say if Joan Smith isn't available, then I appoint John Jones, the successor to Joan. And I could add 2 or 3 successors. So many times in meeting with the family, an individual who's turning 18, who has a developmental disability or has an intellectual disability will say, I appoint my mom and dad to be my attorneys in fact to help me with a variety of these areas. And they are granted the authority to then get access to records, attend meetings, etc. Healthcare proxy is another statute that allows an individual who's 18 years of age and older to appoint an agent called a healthcare agent who would step in the shoes of the individual if that individual is determined to be unable to make healthcare decisions or to be able to communicate those decisions to third parties. And that determination is made by the physician in writing in the individual's medical chart. To the extent the individual regains capacity, they come out of the operation or they come out of ICU, and they're able to then communicate their decisions or make those decisions, then the agent's authority ceases at that time. It lapses. So this can go up and down over time. And it's an important document to have particularly in the area of advanced directives for life, care and comfort, palliative care. We have a separate document called a personal wish statement that is associated with the healthcare proxy, where we go through a variety of scenarios that in event there is no hope of recovery in the opinion of the doctor who's attending the individual, and the person is going to die even with life-sustaining treatment, and where that life-sustaining treatment is merely prolonging the dying process, we have the individual express what treatment they want and don't want in that event. The next option that is sort of this part of this bundle, if you will, is called an appointment advocate. And there are situations where parents may be appointed as attorneys in fact, and they might be appointed as an advocate, but the individual might also appoint someone else. It might be a special education advocate, it might be an attorney, it might be a paralegal, it might be somebody from the ARC, it might be a support broker who could be named as an advocate under an appointment of advocate form to really be a supporter and an assist in decision making and advocate in giving access to information. So, the extent that you can pull these durable powers of attorney, healthcare proxy, and appointment of advocate, these documents that would be created by the individual with an intellectual developmental disability or just any individual who wants to appoint someone to help make decisions. A trustee would be appointed in trust, typically created by a family member, by a parent, in the privacy of a law firm, as these other documents, the power of attorney, healthcare proxy, and appointment of advocate. If you mentally draw a line between the Rogers Guardian go up and the trustee going down, the guardianship, conservatorship, and Rogers Guardian requires court involvement. These last four do not require court involvement. These can be done in the privacy of an attorney's office. The last range of option, many people familiar with supplemental security income or Social Security disability income or disabled adult child benefits, is the representative payee. And if you think about it, the representative payee is there as a safeguard to monitor and manage the income coming in monthly from Social Security Administration. And so the check is made out into the name of the representative for the benefit of the individual beneficiary. Representative account is created, and so as you can see, that's the least restrictive alternative. So if you reflect on the listing here of these 8 options, they are not either or, okay? So durable poverty, healthcare proxy, and appointment of advocate, and representative payee, those last 4, can be in place for an individual at any given time, as could a trustee. However, if a court has determined a guardianship or a conservatorship, the individual lacks the legal authority to make decisions, to execute documents, to communicate decisions, then the availability of the supported decision-making options are really lost. And there is going to be some inconsistency when you're dealing with third parties, and that's a critical factor in the systemic issues we're dealing with. Is it's important that these powers of attorney, healthcare proxy, and other options are respected by third parties, whether they be hospitals or banks or human service providers. So, indicated these alternatives to guardianship, I've described briefly. These are the durable power of attorney, healthcare proxy, advocate appointment, and HIPAA release. There's a Health Insurance Portability and Privacy Act release to release personal information, and the individual can release that information and get access to information to the agent. Appointment and durable power of attorney. This is where, again, I'm being a little repetitive, but repetition is the mother of skill, right? Knowledge. So a principal authorizes the agent or advocate to perform acts on behalf of the principal. Early today, I was with a family, and they said, what does durable mean? Well, durable simply means that even if you become incapacitated after you sign the power of attorney, the power of attorney remains in effect after the appointment of advocate. So even if you become incapacitated, you develop dementia, Alzheimer's, some other progressive disease that will inhibit your ability, the fact that you have a durable power of attorney, that continues to be effective. So it operates really as a substitute for guardianship. So you don't have to go to a guardianship route if the durable power of attorney has been effectively signed. Even you're now incompetent, you still the durable power of attorney remains in effect. For our purposes, in dealing with and working with families who have an individual with a disability who may want to explore alternatives to guardianship, you want these to take effect immediately. You don't want to rely on the occurrence of a specific event, and there are some who would advocate for that, and it's always seemed to me to be logically inconsistent. Because when you ask someone, well, when do you want this power of attorney or advocate form to only take effect when you're incapacitated? And often you'll say, well, I want to retain autonomy, and I'm not sure that I really trust people's decisions. And then, well, I think my response and my analysis is, well, if you can't trust an individual when you're incompetent, when you're competent, why would you want to give them any authority when you're not able to protect yourself? So, I know Florida, and I'm licensed to practice law in the state of Florida, has outlawed bringing powers of attorney or powers of attorney that take effect upon a specific event, such as an incapacity, because of the impracticality of actually using them. Often you can just imagine there's a crisis and you need to use a durable power of attorney, but then you see, it doesn't take effect until the certificate is gotten by a doctor that the individual is incapacitated, and then you have to track down a physician to get out a certificate, and presuming you can actually get that person's attention, you want to be able to then have it signed in a way that will be respected by third parties, and then you're in the third or fourth business day trying to get something done. It just has proven to be logistically very, very difficult. So through the general authority of an agent, to give you a flavor of this, as you can see, it's really dealing with assets, dealing with property, buying and selling and gifting and creating trusts, making personal decision making, maintaining your standard of care, hiring people to assist you, and advocacy in a variety of healthcare and service system things. But very broad authority to act. Now, there's some limitations that are built into the statute. So you can't make out an affidavit. So I use the example of I think it was John Jones or Joan Smith or whatever. I could not have Joan swear out an affidavit on my behalf, giving testimony about personal knowledge that I have. That's pretty obvious, but I can't make this up. Obviously, it comes right out of the statute. You can't make a testamentary will, and you can't engage in marriage or divorce. And I just didn't do that because I thought it would be funny to put in. It just is something that's in the statute. And you really should not self-deal with the principle. It's a conflict of interest unless the instrument, the document itself, says that I'm okay with the agent being able to make gifts to themselves. Moving on to the healthcare proxy. As I said, a healthcare proxy, you designate an agent, and it only takes effect upon the lack of capacity to make or communicate healthcare decisions. And if there's an individual who has signed a healthcare proxy who has an intellectual disability or a mental health challenge, then the physician who is involved in making the determination must consult with someone who has specialized training and experience in either mental illness or developmental disabilities, and that is a requirement of the statute dealing with healthcare proxies. So what can this agent do? What is the authority of the agent? As you might imagine, you can consent or refuse healthcare treatment. That is unquestionably the case. Access to medical records. can employ and discharge providers, fire your doctor, can deal with transfers, admissions and discharges, authorize medication, right? These are good things. And so, as you can see, this is a very, very sort of broad area. Embedded in both the powers of attorney and healthcare proxy are the personal release of information. The HIPAA releases should be embedded in these documents, because that law is a privacy law that has to have a specific release for it. As you can see, why do we avoid guardianship and conservatorship? If we use these other documents, why do we need to avoid? Well, the benefit is in guardianship and conservatorship, it is a public proceeding. There's lawyers, there's judges, there's a lack of control at times if there isn't a successor guardian appointed, but sometimes that is necessary. There's legal determination of incapacity, right? So it takes away the self-determination option that we started with before. It's a transfer of decision-making authority. It can be inconvenient. I mentioned the fact that I am a conservator of this individual person, because we need to transfer that property and to sell the property so we can fund a special needs trust. Because that particular family did not do a special needs plan and did not have in a trust, and it very easily could have been conveyed from a will into the trust, bypassing the probate court through the creation and recording of a deed. Now I need to go to court in order to get a license to sell the property. It's likely when I go to the license to get the license, the court will appoint an appraiser to evaluate whether or not the property is being sold at the appropriate price. That's going to cost money, and it's going to be inconvenient. And I will need to file an accounting with the court when I get my license to sell. So as you can tell, it is a very inconvenient process. And when I sign the offer to purchase, not the other purchase, when I signed the listing agreement, I had to write down this is subject to probate approval and probate proceedings, to put the buyer on notice that this is not going to be a one and done kind of deal. It's going to take some time. It can be expensive, right? And in probate court involvement can be expensive, and that other alternatives exist that I've mentioned. Now, is guardianship and conservatorship a bad word? No. There are situations where guardianship and conservatorship is absolutely required. There are situations where individuals simply lack the capacity to make responsible decisions affecting their health care due to significant limitations in cognitive ability or behavioral challenges. There may be situations where there's a contest between the parents or within the family that renders a power of attorney designation or healthcare proxy or appointment of advocate suspect to, one side saying that, well, this person is being influenced unduly by the other person and therefore challenging the designation in the power of attorney. So in that instance, when people are fighting and bickering, the court is the leveler and resolver of these issues. So do need to go to court. So lack of capacity, an inability to find a suitable attorney, in fact, healthcare agent. Absent the circle of supportive decision-making individuals, you need to go to court. Okay, connection interrupted.
Hold on, everybody. We're having some technical difficulties, but we're taking care of them as we speak.
So, Carrie, why don't you handle the... Okay, I'll move over. Okay, that moved, right? Now, what we're going to move to the next slide, which is if we're doing a guardianship should be narrowly tailored. Again, looking at the least restrictive alternative, and we want to make an individual functional assessment through either a medical certificate or clinical team report. These are court-generated documents that provide the substance or the evidence showing the need for a guardianship. Is it earlier guardians have powers to make personal decisions regarding a wide variety of areas? A question that often comes up, and I'm not sure where it emanates from, but people are concerned about, am I going to be liable for any acts that the protected person incurs by way of expenses or debts? And the answer is no. There is no liability. You're personally liable for the specific act, but that is not something to really validly worry about. And if you think about the guardianship statute, it emanates from the common law and rich case law and statute that grants powers and responsibilities of somebody who needs protection, such as a minor. And so that's where this is emanating from. I feel like I'm repeating myself, and it's purposeful. Guardian only needs to exercise authority necessary. So only that amount that's necessary to protect the interests that are at stake. The guardian is also responsible for saying, I'm not the czar here. I'm not the dictator. I want to hear what you have to say, and I want to encourage your participation. I'm going to encourage your independence. I want to encourage you to become as capable as possible, and I will absolutely seek to incorporate your preferences and act in the person's best interest. So the other aspect here that is important to recognize is we want to implement what the person has expressed so much so that it's not so much what the guardian wants, but it's a substituted judgment. So as a very simple and sort of inane example, if someone says, I love strawberry ice cream, right? I really love strawberry ice cream. And yuck, I hate strawberry ice cream. You're having chocolate. That's sort of an inane example, right? But as a guardian, you can say, well, I respect the fact that you want strawberry. I happen to have an aversion to strawberry ice cream. I prefer chocolate, but because you want strawberry, we're getting strawberry ice cream. Crazy example, I know, but that's the best I can do to just demonstrate this notion of respecting the express preference of the individual. Massachusetts, as in many other states, requires the guardian to file a written report on a court form called a Guardian Care Plan form. That is due 60 days after you get appointed, and you have to do that annually. And so the areas that are required to be in a care plan report. And believe you me, the courts do in fact read them. And so you don't file it, you'll get a notice and saying, you've got to come in and file the report, and they might give you some amount of encouragement and education about that. And then if you continue to ignore them, they'll come in and say, well, do you really want to be a guardian if you're not going to report and fulfill your obligation? So you can file that report. These are the limitations that I referred to earlier when I mentioned the Rogers. That would be under the extraordinary treatment for decisions regarding substituted judgment determinations. Those are advanced medical decisions, antipsychotic medication, etc. Admittance to nursing facilities and involuntary commitments all need specific court authority by the court, and it's subject to the person who is subject to the guardianship having counsel. So here's an example of some of the extraordinary treatment types of things. You can see it's pretty heavy-duty stuff. Administration of antipsychotic, order medication, life-prolonging treatment, etc. There's sometimes a question of, does this really rise to the level of extraordinary treatment? My experience is consult with an attorney or consult with the DDS service coordinator who can run it by the DDS legal counsel, either private attorney or an attorney who can give you some guidance. So a couple quick things before we open up to questions. I think we have maybe 10 minutes left, which is great. A family care program, many may be aware that this part of the Massachusetts Medicaid state plan, where a family member can be hired as an AFC provider for a son or daughter. However, one of the limitations is that an AFC provider cannot be a guardian. You cannot be a guardian. It's legally responsible. So what some folks do is that one parent will be the AFC provider and the other parent will be the guardian. This underscores the value, perhaps, of alternative strategies to guardianship using a power of attorney, healthcare proxy, and the appointment of advocate form. We have a relatively new statute for interstate transfers. So if you moved from here, from the New Jersey guardianship, or you have a guardianship in Massachusetts and moving to New Jersey, we now have an efficient approach to transferring that administratively from one state to another, rather than having to submit new clinical evidence supporting the need for a guardianship. So there's some full faith and credit being given to the courts, the one state's courts, as to another state's enactment or enforcement of that transfer. It's Byzantine. There are a number of steps and hoops to go through. For something that's supposed to have made this a little easier, frankly, it makes me go on fire when we do one of these, because it can be somewhat cumbersome. And with that, I'll turn it over to Carrie and see if we can turn some questions.
Thank you, Fred. I appreciate all that good information. So I'm just looking at the chat box and slide. We're still on slide 10. I think. Can you? Are the slides resolved, by the way? From is anybody having problems? No. The question and answers slide there. You copy of the presentation after tonight's webinar. All righty. Okay, so I apologize for that. I don't know what happened, but again, you will be getting information. So at this point, we'd love to answer your questions. So if you could just chat them into us, read the question, and Fred will answer you. Couple minutes. Is just so important is how I get a lot of questions here at the ARC about how do I know what guardianship I need, and I think it's good to be able to talk with people that also support your sons and daughters, teachers and maybe educators, staff people, all sorts of different professionals in their life, their physicians, maybe their counselors, because so many people are different for different individuals in situations. So that would be something. So we do have a question Martha, is durable power of attorney something that will transfer over state lines?
For that question, the answer is yes. A durable power of attorney is respected in all jurisdictions. There's a Uniform Durable Power of Attorney Act, which we track. There might be some minor alterations and changes from the Uniform Durable Power of Attorney, but it is a document that is respected. There are some idiosyncratic differences in some states. Massachusetts had a devil of a time over the years for banks and financial institutions and individuals who try to make things difficult because they're concerned about their own liability, saying that, well, if a power of attorney is over 3 years old or 5 years old, it is in fact quote-unquote stale and therefore needs to be refreshed. And there's a legal basis for that other than sort of internal administrative procedures. And that is now outlawed in Massachusetts, that a durable power of attorney must be respected despite the fact that a lapse of time. And there are some penalties imposed on banks, particularly if they refuse to recognize a power of attorney due to lapse of time. So I hope that answers your question. I think that Ron had a question about repeating the information about the care plan report. As I said, the care plan report is due 60 days after appointment, and then you must file it annually. And this report can be found on the mass.gov court's website in Guardianship. And now we have to describe the mental, physical, and social condition of the individual, describe the living arrangements, and what services the individual receives, describe the frequency and nature of the contacts the guardian has had with the protected person. If the person is in a facility or in a nursing home or in a restrictive residential setting, should that setting continue? And then there's an opportunity to talk about plans for future care. Are there things in the works, jobs, change in residence, etc.? And then, is the guardianship something that should continue, or should we be limiting the guardian's authority over time? And again, that comes from a court-generated document. So, other questions? Is parents about guardianship and alternatives, so thank you. A question about limited guardianships and now how the public interprets it. Seems confusing because it's not clear or educated. You're absolutely right, Julie, that there may be and this is one of the challenges in guardianship when you look at it from a public perspective or systems perspective. As you know, the ARC of the United States recently redid its autonomy, decision-making, and guardianship position statement. You can get that from the ARC of US website on position statements under the individual rights section. And one of the areas that position statement speaks to is the need to educate lawyers, judges, hospitals, healthcare providers, social service settings, school systems around what a guardianship is in terms of the limits and the limitations of the guardianship, and so becoming understanding that alternatives do exist. We have a long way to go in explaining that and educating people. The reality is, sadly, that often if someone is a limited guardian only for health care, they will represent, or the third parties will represent, that they're their guardian for everything, right? And that's just not the case. But it is something that requires, I see, education, like anything else. it has to take time to generate experience and confidence in to guardianship and understanding what supported decision making is about, that supports self-determination. The state of Texas, and Texas, big state, has great food, right, music. The state of Texas might not be as the most progressive state, is us up in Massachusetts or in California might smugly say, "Oh, Texas, they're not as progressive." But Texas implemented a substituted judgment statute that requires judges to inquire as to why powers of attorney and healthcare proxies and lesser restrictive alternatives haven't been employed. And you demonstrate that those are not appropriate if you want to proceed with a guardianship. So, and they have some trainings out there throughout the country where a lot of people are talking about decision making, even beyond the powers of attorney and healthcare proxy that I, as a private attorney, assist people in using. Annually under guardianship require you to also go to court each year? Great question. That comes from Ron. No, you can mail the guardianship form, and is all that is required. And I do want to make a distinction between the care plan report that can just be filed annually and the Rogers order that you do have to petition to extend your authority to administer psychotropic medication. So I don't want people to be confused. And we normally, for clients who have come through our firm who have a guardianship in place, we'll often do first care plan report and base that on either the IEP or an ISP or some other, documents, and we'll build up, and that form over time can then be used as a template for future care plan reports that will be updated as events progress over the years. Well, I think that exhausts the questions that we've had. So I'll turn it back to Carrie.
All right. Well, I apologize for the technical issue, but you will, like I said, you will be getting a copy of the presentation. And I want to thank you tonight for attending our webinar, and Attorney Misilo for giving us this wonderful information. And again, I'm excited that people with intellectual and other developmental disabilities have more options to be safely supported without to always have to go through a court system. So that's exciting to me. But thank you for attending. After the webinar is done, you will be directed to a 5-question survey. If you could just give us a little feedback on tonight's presentation, and then give some ideas too if there's other types of information that you would be interested in. This has been recorded, so it will be on our on-demand series. So if somebody missed it tonight, they can actually view that by going to ARC and looking at our on-demand catalog. So thank you all for attending, and I hope you have a great night. Care.
You know what I think happens is that I'm going to my IT person.
Okay.
But I think they time us out.
Okay.
After like 20 minutes or 30 minutes. I get timed out.
Okay, that probably was, you're right.
I probably should have known that. But that's